guys, I'm Durga and you are into my channel Learn with Durga. Today we are going to see about incorporation of company and incidental matters thereto. Hello guys. So now let's get into the video. So the video is about incorporation of a company and incidental matters thereto. So now first we are going to see what is a company. So company is a separate legal entity with perpetual succession for lawful purpose. So before we are going into the definition, we want to know what is a company. So company is a separate legal entity. What is mean by separate legal entity? So separate legal entity means the company is legally separate from members. So now let us take an example as X. So there is a person X, okay. So the company is XY Limited. When the company is incorporated, the X and XY Limited are different members. X and XY Limited are different members. XY Limited will have its rights, powers, and it can own a bank account. It can enter into contracts in its own name. So what is perpetual succession? Perpetual succession means the company moves on. The members may die in some instances, or the members may be changed, or they may be removed from the company, but these things will not put an end to the company. So the company will move on. Only the law alone can bring an end. Law alone can bring an end to the company, okay. So this is a company. So company means perpetual succession and separate legal entity. So the company will have its own powers, rights, etc. and it will have perpetual succession. It is formed for a lawful purpose. Now let us see who are the promoters of the company. So a promoter is a person who initiates promotion of a company. So they not only do the promotion of the company, they do various acts and they put various efforts to bring the company into the existence. They are the main persons. So they perform necessary formalities for the registration of the company, and they find the directors of the company, shareholders of the company, and also they acquire various business assets for the functioning of the company, and they negotiate the business contracts on behalf of company. And to bring in company into existence, promoters are really necessary. So now let us see the definition of promoters. Section 2 of 92 says who are the promoters. So who has been named as such in prospectus. What is a prospectus? Prospectus is a booklet. So if you say prospectus is a booklet or pamphlet, something like that, that is given to the investors. So if we are investing in the company, we have to know about the details of the company and details of the shares and regarding the offer the company is giving. So the prospectus is being given to the investors with such details, okay. So in the prospectus, the company would be given the name of the directors, okay, and promoters. So that persons whose name has been entered there are called as promoters, and who has control over the affairs of the company. So example, shareholders, directors, so they have control over the company, right? So the shareholder can also, because he is a member, he has control over the company. So they are also a promoter, directors are also promoters, and in accordance with whose advice, directions or instruction, board of directors act, okay. So they are the promoters. This is a definition of promoters given in section 2 of 92. Okay. So now we are going to see about the formation of company. Okay, now first we have seen what is a company and who are the promoters. Now we are going to see about the formation of company. As per section 3, company is divided into two categories. One is private company and the other one is public company. So now let us get into the detail of what is private company and what is public company. Now we are going to see about the minimum number of persons to be in the incorporation of a company. When we see a public company, in public company the minimum number of members should be 7. So 7 or more persons should be the part of the company to be called as a public company. If it is a private company, there must be 2 or more persons. If it is a one person company, one person is enough to incorporate a company. Now let us see what is a private company. Private company means a firm held under private ownership. So now what is a private ownership? So private ownership means a person owns the company for his own profit. Okay, he runs the company to get enough profit for a survival. Okay, it is owned by one person or a small group of people. So a person runs his company not for the society's benefit but for making profit of him. Now we are going to see about the companies limited by shares and limited by guarantee and unlimited company. So now first we are going to see about limited by shares. So what is meant by limited by shares? So the shareholder, the company will have of course shareholders. So those shareholders may be called upon to contribute only to the extent of amount which remains unpaid. So now let us take an example. Mr. X, okay. Mr. X is a shareholder of a company. He pays rupees 10. So the value of the share is 10 and he pays rupees 5. So when the company is limited by shares, he may be called upon to pay the remaining amount of rupees 5 only. Okay. So when it is limited by guarantee, company having liabilities of its members limited by memorandum to such amount as member may respectively undertake by memorandum to contribute to assets of the company. So when it is limited by guarantee means a company will have liabilities of its members limited by memorandum. In the company's memorandum, the members may give a guarantee to pay such amount on the liability of the company. So they may be called upon only to that amount of which they have given guarantee in the memorandum. Now we are going to see about unlimited company. Unlimited company means there will be no limit on liabilities of members. The liability ceases on when he ceases to be member. So now take Mr. Y as a shareholder of the company, unlimited company. So when Mr. Y leaves the company, that's it. He cannot called upon to contribute to the further assets of the company or for the liability of the company. So liability is not unlimited till the time company is not wound up. So member may be called upon on winding up of the company. Liability of each member extends to amount of company's debt and liabilities. So the member may claim contribution from other members. So this is the unlimited company. So we have now seen about the company's minimum number of persons, private company, and the company limited by shares, limited by guarantee, and unlimited company. So now let us see what are the steps for incorporating a company. So the first step is reservation of name by filing e-application. We have to file an application in the portal of the government of the name which we desire to reserve. We are going to keep a name to the company. We have to reserve that name by filing an e-application. The government will see to that whether the name is not containing any offense words or something like that, and then they would give the name to us after few days. So we have to first reserve the name of the company, and then drafting and signing of memorandum of association and articles of association, and we have to submit that memorandum of association and articles of association to the registrar of the companies. So regarding memorandum of association and articles of association, we will be seeing that in the upcoming videos. These documents have to be e-filed and e-stamped. We have to file them electronically and have to stamp them electronically. And then we have appointed certain person as directors of the company. So those person must write and consent to the director or registrar of companies that we agree to be the directors of this company and have to submit that electronically. And then submission of statutory declaration of compliances and other declarations. So the persons must submit certain regulatory compliances. So some which will be like that must be we have to follow it. There will be certain rules. So we have to comply to that. Okay, we are agreeing to those terms and conditions. And then we have to pay fees and amount of stamp duty electronically. So fees is that for registration of the company. We have to pay them electronically. And then obtain certificate of incorporation digitally signed by registrar of companies. So what is certification of certificate of incorporation is that we are registered company. So the registrar of company will give us a certificate digitally signed. We will be getting that through the online portal. Okay, next we have to file declaration about address of registered office. We will be having an office. We have to confirm this is our registered office. That's it regarding the steps for incorporation. We have to follow these steps to get our company incorporated. Now we have seen about the incorporation steps, etc. If the company incorporates by furnishing some false or incorrect information, then what will happen? The tribunal will order the company to remove the name of the company or wind up. You need not do the business because you have given incorrect information. Okay, and then the company may be changed to unlimited liability, or it may change its memorandum of association or articles of association or other orders as it may think. The tribunal can give these and all other also if we have furnishing incorrect information. Okay, so we have to furnish the correct information, proper information, because they would be the tribunal would check the information given by us. If it is incorrect, he may remove the name or wind up or change our liability or change the memorandum of association, our articles of association. So we have to give the proper information. So before making any order, so now the tribunal has found that we have incorporated the company by giving incorrect information. So what he will do is that first he will give the company a reasonable opportunity of being heard. He will say that Mr. Company XYZ Limited, you have given incorrect information. So I'm going to make some changes in the name of you have to wind up the company or you have to remove the name of the company. Like that, the tribunal may give some orders. So you will be saying that, so the tribunal shall take into consideration the transaction entered into by the company. So we will see whether the company has given proper information regarding the incorrect information provided by the company. If the tribunal is satisfied, he may cancel the order. If not, he may wind up the company. If you find the video useful, please do share to your friends and like the video and subscribe to the video for further more videos. We will see in the next video. Please do drop your comment in the comment box.